If you find yourself given notice of a foreclosure or a pending foreclosure action, there's a few things that are going to happen under the proper procedures under Iowa law. First, you're going to receive a notice of right to cure the default. You should receive that by mail. It should tell you how many days you have to cure the default and what the default is. Specifically, if it's for non-payment of a mortgage or a note, it should tell you exactly how much is due and exactly how much how much interest and principal should be paid by the deadline to cure the default. If you do that, follow those instructions, then no foreclosure should occur. If you're not able to do that, what you will likely encounter after those 30 days or whatever the deadline is have passed is you'll get what's called an acceleration notice. The acceleration notice normally says your note and mortgage you signed at the beginning of this process when you purchased the residence allows us to accelerate the debt if you have defaulted. And the reason that that is normally sent is because any attorney who's doing the foreclosure process under Iowa law, if they want to ask for attorney's fees during the foreclosure process, they have to show the court that they have sent an acceleration notice beforehand. So once you've received the cure notice, the acceleration notice, the next thing you'll receive is you'll be served with a petition of foreclosure. You still have some options at that point. First of all, you should consult an attorney after you receive that first notice so you know all your rights and protect those rights as quickly as possible. There are plenty of attorneys out there. Do not charge all that much money that can get involved and help you. But if you've been served with a foreclosure petition, you need to know that you need to follow the instructions on the original notice. It will tell you exactly how many days you have to file an answer. You should hire an attorney if you are able. If you're not, you should still file an answer within the 20-day period. If you cannot file an answer within the 20-day period that's allowed, you should contact the opposing attorney. The phone number and address of that attorney will be listed right on the pleading, and let them know that you need more time and get approval from them for more time. When you file the answer, you have an option to file for what's called a demand for delay of sale. What the demand for delay of sale says, if this is a residence that is your homestead, and you file for that demand for delay of sale, it says you have 6 months, in most situations, you have 6 months before the sheriff's sale of that home after the foreclosure decree is entered. So you're going to have the entire foreclosure litigation process first. You'll file your answer, there might be some discovery, and then the foreclosing attorney is eventually going to get a decree of judgment if it's a legitimate case. And then, once that decree is entered by the judge, you have 6 months to try to sell that property, essentially, or come up with the money to cure the debt. So you can get the foreclosure reinstated or get it paid off, get the mortgage paid off by the sales proceeds. So the demand for delay of sale is probably the most important thing to remember in that process. There are defenses to foreclosures, but frankly, there's not that many. It's a very simple process. You sign a note backed by a mortgage to pay back a debt. If you do not pay back that debt, that mortgage normally states they have the right, the lender has the right to come back and take your home from you. The only real defenses you can allege if you are truly in default on payments are procedural defenses. And all that is going to do really is going to delay the inevitable if you are behind on payments and cannot make that current. So again, I urge you to contact an attorney as soon as possible, but also remember that you do have rights under the law to protect you from immediate foreclosure and sale of your home.